Good evening. Hello, everyone. So wonderful to have you with us for this very significant conversation on copying, copyright, and plagiarism. In our web in life that we are leading today, these are issues that have popped up even more prominently than ever before. And to have this discussion in our series called Arts and the Law, what they do not teach you in art school,
গুলোতে
our session today is going to be led by
অডিওটা ঠিক ছিল
the legal expert, Mr. Amit
ঠিক আছে
Datta. May I request everybody to please keep themselves on mute? And with us, as discussant, is Anita Ratnam, artist and arts entrepreneur. In recent times, this is just the last 1 week, I have come across 3 cases that I would like to mention today in passing. That determine the topic actually: copying, copyright, and plagiarism. You know, in Kathak, which is the form that I have learned, it is often said when you are with your guru that dekhya, dikhya, and parkhya. You see, you observe and learn by repetition, and then you leave your hand of the guru and do your own innovative stuff. But the question then arises that we are sanctioning copying up to a point, and then issues of copyright come in. How do you divide the two? Very recently, a friend in another case, a friend of mine turned around and told me that she'd organized a very beautiful festival online like it is done today. But suddenly, in the segment of the live performance, the stream stopped. And the issue was copyright. How is it that traditional pieces that get danced in the repertoire of all our classical forms, for instance, who owns the copyright for them? How can you stop a streaming this way? And who stops? Who gets to gain in that process? And the final thing is a story about plagiarism. I think it was about 4 5 days. One of the groups, an artist group that I'm a part of, suddenly had these messages flying right, left, and center because a speaker had presented a talk in which, word for word, there had been a lift from someone's doctoral thesis, and somehow the world is now no longer, you know, under the carpet kind of world. It's all there in the public domain because we are dependent on internet, and we are dependent on the world wide web. And so these things don't remain hidden anymore. They're coming to the forefront, which is making our world quite a anxiety ridden world, because are we knowingly and unknowingly, very often it's unknowingly, uh, doing theft of intellectual property? It's a very complex subject. It has many elements to it, but in the hope that he will be able to make it simple, I welcome to our panel discussion our legal expert, Mr. Amit Datta, partner of the defining IPR firm called Sai Krishna Associates. Finding him, I consider an act of real good luck. He is probably India's authority on the music part of the creative industries. He's been a member works very closely with IPRS, which is the society which protects copyright for music as well. And we have Anita Ratnam, who really needs no introduction. So I welcome both of them. And I invite Mr. Datta to begin the presentation. He will be using a PowerPoint. We have people who are from the creative domain in India and overseas in this webinar, Mr. Datta. And many of the questions that they want to ask is also about, when you're sort of moving from one country to another, do laws change? What happens? So keep that in mind as well when you speak. Thank you very much. And Bismillah. And Anita, thank you. We will have him speak first, and Anita will come on a little later after he makes the first presentation. Yes, Mr. Datta.
Thank you, Dr. Sethi. I have to confess, I'm a bit worried now because I'm comfortable speaking in conferences full of lawyers, but when I can quite clearly see that they're very accomplished artists on this conference, and I'm suddenly more intimidated because lawyers often have, it's one of the talents of lawyers is to ruin things for the creative community. I'm very conscious of that, or complicate lives for the creative community, and I'm conscious. I'll try not to do that. Dr. Sethi, if you can ask the tech people to upload to share the presentation.
Yes. Sushant, can you hear us? Can you show the presentation? You are not going to share it from your own.
I can share it as well. I'm so sorry.
Yes, actually, from that participant next to it, the share, the green screen.
Yes,
yeah,
I've got
share screen. Yeah, we could do it from here. That's why I asked you yesterday.
Yeah, no, I'll do that. No problem.
Yeah, it didn't work quite so smoothly the last time, so I'm a little hesitant.
Understand. Right. Down to business. Copying, copyrights, and plagiarism in the arts, terms that I've dealt with over my last many years in the legal profession, but terms which I've learned often to my detriment have deeper meaning, nuance, and complexity than I catered for on many occasions. Effectively, if you look at the copyright and the creative sector, lawyers like me who like certainty and clear terrains, like to divide the copyright or the creative sector, as we call it, into various fields or subsectors. Print, you have music, we have dramatic arts, we have film, we have broadcasting, we have art, in terms of painting, sculpture in various patterns, and then you have new media. So this is the general legal sort of and government creative sector. So I thought, I'd take you all through, a basic understanding of what copyright law is. I started doing copyright law, sometimes stumbled onto it rather in 1999 when I was a glorified bag carrier for my first class a government meeting to talk about copyright law. And at that time, the rage was the internet laws and cyber laws, and we were on the cusp of the millennium and Y2K. And I remember, coming across copyright law, and I found it terribly interesting. And effectively, if you want to understand what copyright law is, it's essentially a bundle of exclusive rights. It's a series of rights, largely referred, if you want to go by the Commonwealth sense, as a negative right, which is a right to prevent others, to exclude others from exercising, any act or action or taking any action in relation to something that you create. It's also a positive right, which is a right to benefit from copyright ownership, which are understood as the exclusive rights. Contrary to a lot of assumption, copyright in India, as in other parts of the world, is a statutory creature. It's not traditional, it's not customary. The law in itself recognizes it as a pure statutory right, and that's a very clear disposition or mandate under Indian copyright law, which says that no person will be entitled to copyright or any other similar right in any work, otherwise than in accordance with the provisions of the Copyright Act. The Copyright Act 1957 is our law, or our version of what the four corners of copyright is. So whatever is recognized, protected, mandated, limited, or excluded is set out under the Copyright Act, and so it's a self-contained law. Copyright in itself is a statutory right. It's created by legislature unlike your common law rights, which came from England, which India recognized once we transited to being an independent country. Under our constitution, we recognize various common law rights as well. The right of defamation, for instance, is a common law right against defamation. So unlike common law rights, in copyright in India is a purely statutory right, as in other countries as well. So when I said it's a bundle of rights, one of the things to take into account is there are certain works or certain creations that are recognized under the Copyright Act 1957. And those are classified as, and I want to underscore the word original first, because this is a very critical aspect of copyright law. Original literary works, artistic works, dramatic works, and musical works. So these are works created by a human being, by a human artist, by a human creator. And then you have sound recordings and cinematograph films, which are traditionally known as neighboring rights or derivative rights, which are an amalgam or collective works consisting of either literary works, dramatic and artistic and musical works. So the primary works that copyright started recognizing first off. And as technology developed, you had the wax cylinder, and then you had the gramophone, you had sound recordings, and then you had cinematograph films. As technology developed, eventually, because of the economic imperative, they were also brought under the scope of copyright. But first off the base, you had recognition for what's known as original literary works, artistic works, dramatic works, and musical works. In effect, and what are these works? How do you define them, and what do you mean by them? Literary works are quite simply, there could be lyrics of a song, there could be books, text, articles, papers, computer programs, tables. So the definition under Indian law is an inclusive definition, which means that it identifies some things but uses the word includes, which means that everything else that is not defined but meets the criteria is included. So lyrics, books, articles, papers, or literary works, which are textual. You have musical works again, which are a work consistent of music and includes any graphical notation of such work, but does not include any words or any action intended to be sung, spoken, or performed with the music. So effectively the melody, only the musical composition. Now, one of the departures where India is concerned is because the Indian oral tradition was taken into account when defining a music composer. The Indian Copyright Act was very careful to include a person who composes the music, regardless of whether he records it in any form of graphical notation. So, music sheets, etc., which are common in the West to set out musical compositions, are not required under Indian law because we have an oral AURAL tradition where music compositions and music is concerned. And then you have artistic works, which again could mean a painting, a sculpture, a drawing, engraving, a photograph, works of architecture, and any other works of artistic craftsmanship. So a very broad sort of definition, which includes a host of works which have artistic merit. And then finally, dramatic works, which includes any piece for recitation, choreography, and entertainment, the scenic arrangement or acting. So effectively, dramatic works would be a screenplay for a film, a script for a theatrical production, choreography for a ballet or a dance performance would be covered within the definition of a dramatic work. And now you have an additional right that is recognized apart from the exclusive rights, which are called performers' rights. Since 2012, Indian law has taken into account the fact that performers and performances are equally capable or should be capable of protection. This resulted from a worldwide surge and a demand from actors and artists whose performances were included in audiovisual recordings like films, etc., to be recognized. And you had something called the Beijing Treaty for Audiovisual Performers, which was signed in 2012, just after our 21st June 2012 amendments were enacted. And actors, singers, dancers, and their performances are recognized. So effectively, what is recognized is each performance is protected for a term of 50 years, and its exclusive rights are no less than the exclusive rights which are given to artistic, literary, dramatic, or musical works. So you recall I talked about originality, and one of the important criteria under copyright law is for a work to be protected, quite apart from the fact that it should be created by me or you, is it original enough? And a lot of courts have grappled with the fact that, if it's a mundane sort of compilation, say, of material, a telephone directory, should that be protected under Indian copyright law? And in 2008, the Indian Supreme Court did something that was a departure, both a welcome break from its Commonwealth tradition, where it went away from the UK, but not so far away from the Commonwealth, because it adopted the Canadian standard, which in essence rejected the UK criteria of labor. The UK courts held, and the UK copyright law held, that hard work and labor, sweat of the brow, should be adequate to make a work be deemed as original. The Indian Supreme Court disagreed and said there should be a modicum of creativity, which means that there should be it should be an element of creativity, but not in the sense that nobody knows about it, or it's non-obvious, but it should be a creative sort of output, and that would make the work original. So the criteria for protection of a literary work, a musical work, artistic or dramatic work is originality, which is absolutely crucial, because that determines the extent to which you can get protection. For instance, if you have a well-known public domain work to which you make changes, so the extent of your changes, the extent of your improvements and additions to that work, for instance, a work of choreography, a dramatic work, a set of lyrics, musical composition, you could, if it's original and deemed original, you could claim copyright, notwithstanding the fact that a part of that body is well known or is in public domain. So these are the terms of protection. The longest period for term of protection is for our original works, which is the life of the author, plus 60 years after the death of the author. So this is intended not only to protect not only the author during his or her lifetime, but also provide economic benefit to the legal heirs of the author. And sound recordings and cinematograph films being derivative works is 60 years from date of first publication. And then you have something called a broadcast reproduction right for television channels, etc., that broadcast works, which is a limited right. These are, to understand what are the exclusive rights under the Copyright Act, you have on the first column the right, which is the exclusive right. In the second column, starting from the left of your screen, you have the right, you have the works, and then you have examples, for instance, of how these exclusive rights can be exercised. So generally speaking, across our original works, you have rights such as reproduction and storage, distribution, communicating a public performance, or communicating to the public. You have adaptation. You have a rental right, which is limited to the collective works. You have a right against translation, which means you can control as a copyright owner the right against translation. And then you have neighboring rights. The adaptation right is very crucial, because the adaptation right is a right for you to authorize or to make alterations to works, to abridge works, and to change works. Coming back to the kind of construct of the theme of this conference or this session, I've as a lawyer, I've often grappled with claims relating to plagiarism or copyright infringement. Now, in effect, while they seem to overlap in a sense, they are not completely, let's say, completely akin to each other. Plagiarism largely is a wrong that is directed against an author who may not be an owner of copyright as well. But copyright infringement is something that's purely directed against an owner of copyright. Plagiarism can often consist or be limited to using somebody's work or idea without providing credit, but not being actionable in terms of substantial copying. You may take the idea expressed by an academic, for instance, in a paper, but not credit them or not reveal that the idea or the proposition or the argument was first propounded by another academic. That may amount to plagiarism, but it will not amount to copyright infringement. Copyright infringement largely is concerned with the use of expression, or rather the use of the actual manner and the content of how your copyrighted work is expressed. So it could be sequences of words in a book, it could be images, it could be photographs from a choreography perspective, it could be the actual sequence of choreography. And effectively, copyright infringement, that's where it departs, is actually an appropriation of a revenue stream. This is an exclusive right from which only an owner can benefit economically. And so copyright infringement presupposes that this is an appropriation of a revenue stream. So largely that's the distinction between plagiarism and copyright infringement. And it's important to keep that in mind because, as I said, what could be plagiarism and a moral and an ethical issue will not always be illegal in the eyes of the law. And taking this the subject further, you had a very interesting case in the 70s relating to a theatrical production in Delhi, where the film producer was very enthused with the theatrical production and wanted to make a film. The director refused to agree to the making of a film. Subsequently, a film was made, and this went up right to the Supreme Court. And the Supreme Court, while grappling with the issue of what is protectable and what is not protectable, and also taking into account the fact that copyright law required copyright law was not only there to protect exclusive rights, but copyright law was also directed to preserving a balance between the right to access creative works, the right to of the public and the general public to use and access creative works in certain limited instances, and also the extent of protection. One of my favorite examples of what copyright law protects is perhaps rightly kind of explained by looking at the recipe, for instance, apple pie. And if I write out the recipe for apple pie, that gives me a monopoly on the making of apple pie. All it does is gives me a right over the recipe and the way I wrote it out. Now, if somebody else has a different way of writing the recipe, it doesn't infringe my right. And so that explains the distinction between copyright protection and the protection of an idea or a concept. And so the Supreme Court said there can't be a copyright in an idea. There can't be a copyright in a subject matter. There can't be a copyright in a theme or a plot or historical or legendary facts. Here you would be limited to infringing if you were actually appropriating what is the expression of the idea. And the Supreme Court also took into account that if you have the same idea and you're working off the same idea, you are bound to have similarities. So innocuous similarities read with dissimilarities will not result in copyright infringement. And they obviously put it down. And Indian courts, taking a lot of guidance from UK courts traditionally, have relied on the wisdom of judges, good or bad, and have left it to the ear of the judge or the eyes of the judge. And the test often is or that of an ordinary man, with the judge rightly or wrongly supplanting himself or herself as an ordinary person. The assessment of whether he or she is the opinion that the unmistakable impression, as the Supreme Court said, is that the subsequent work appears to be a copy of the original. And so that's generally been the criteria. And Indian courts from the 70s have followed largely this judgment and this line of thinking in assessing what to protect and what not to protect. The interesting part was also that what was being compared here was a play versus a film. And so that becomes very relevant from a theatrical production versus a film, because the court took into account the fact that when you make a film, the expanse and the perspective of the production and the presentation is bound to be much broader and have many elements which a theatrical production would not be able to present. And so therefore in such cases a case for infringement would be tougher to sustain. So in essence, the distinction, again, there was an interesting, suggestion, in a court proceeding that I'll talk about, when the question arose as to whether Shakespeare's works were dramatic works or were they literary works, and if they were dramatic works, could they be classified as literary works? And the court said, surely it's nobody's case that Shakespeare's dramatic works, they are undoubtedly dramatic works, they're plays, but it could be nobody's case that Shakespeare's dramatic works don't have literary merit. But the law recognizes different classes of works. And so if you take the disconnect, so to speak, or the separation or segregation between what's a literary work and a dramatic work, you have, starting from the top, a story based on a plot, characters, and dialogues. So in effect, the amalgam of this is would fall within the criteria of what's known as a literary work. But when you take the story, plot, characters, and dialogues, and you express them, or you lay them out as a screenplay or a script, as a direction for actors, for choreography, for instance, for dancers, etc., then that assumes the character of what's known as a dramatic work. So that's the essential distinction between a literary work and a dramatic work. And this, the Supreme Court looked at in a very interesting case in 2009 in relation to Dr. Kota Karant, who had authored, some prasangs for a series of ballets where he had made changes to the traditional form of the ballet relating to, the rag and tal, and scenic arrangement and costumes, etc. And he had left in a will bequest, his literary work, so to speak, in favor of his companion, Miss Malia. And the Manipal Institute actually held an exposition where some of these prasangs and these ballets were performed. And Miss Malia sued for copyright infringement, and one of the defenses was that what we've kind of presented or used are dramatic works, and the lady did not have a bequest in a favor of dramatic works. The bequest was limited to literary works. And the other defense was that Dr. Karant could not have claimed copyright over public domain works. So on the aspect of originality and copyright ownership, the Supreme Court disagreed and said, no, he does, because his changes are original enough. His modification and changes to the prasangs are original enough for him to be able to claim copyright and enjoy copyright. it did draw a distinction between literary and dramatic works. He said that, look, the Supreme Court said that, look, the law has made this distinction, and this distinction is a very clear legislative intent to make a separation between what is a literary work and what is a dramatic work. They did protect Miss Malia by virtue of a residuary clause in the will, because that left anything that was left, in her favor as well. But they said that copyright in respect of a performance of dance would not come within the purview of a literary work. That would come within the purview of the definition of a dramatic work. And so choreography is effectively a dramatic work, and this is probably the only case that sort of kind of settled the question as to whether choreography, the performance of dance, would be, how would that be categorized? As I said, copyright law is not about, exclusive rights. One of the fundamental propositions of copyright law across the world, taking from international conventions, is that there must be a balance between, as I said, the rights of the exclusive rights of owners, and as compared with, or as balanced with, the right of the public to access copyright works. So internationally, the leading convention is the Berne Convention. It takes into account that there will be exceptions and limitations to copyright law. Copyright law is not an absolute monopoly. Copyright law is not an absolute monopoly, and accordingly, Section 52, excuse me, this Section 52 of the Copyright Act looks at fair dealing, and so we've now, if you're in the US, you'll be used to a term called fair use. If you're in the Commonwealth countries, in the UK and in India, we are used to a different term called fair dealing. Now, this is Section 52 is what is known as the exceptions provision under copyright law. The exception provision means that the acts that are described under this provision will not amount to an infringement of copyright, even if a work is protected under copyright. So, for instance, a fair dealing for the purpose of private or personal use, including research, is not deemed to be an infringement. I can use a work for criticism or review, and that will not be deemed as infringement. I can use a work to report current events and current affairs. It will not be deemed as infringement. All of this is subject to the word fair dealing. In effect, fair dealing means exactly what its English kind of meaning would imply, dealing fairly with a work. So it doesn't mean that I can pick up a book and copy 10 chapters, or I can pick up a play and copy 3 acts out of 4 acts, or 5 acts, or 2 acts out of 5 acts, or 2 of the most important acts out of 5 acts, and say it amounts to fair dealing. It doesn't. The extent of the use is important, and it depends on a case-to-case basis as to when you can use a work for the purposes of fair dealing, and when you can't use a work for the purposes of fair dealing. Again, publication of a work in a collection which is composed of non-copyrighted matter for instructional use of short passages, again, that's allowed as long as, you are limited to passages of the same author within 5 years, etc. So there are limited, narrow exceptions to copyright law, which exclude anybody claiming copyright infringement. The making of painting or drawing or engraving or photograph of a work of architecture. So, for instance, if I take a photograph of a work of art, that's not copyright infringement. If I make or publish a painting of a work of architecture of a building, it doesn't amount to copyright infringement. Again, the performance of a literary, dramatic, or a musical work during a bona fide religious ceremony, or a government function, or a marriage for that instance, or any social festivities in a marriage are deemed not to be infringing acts. In addition to this aspect of copyright law, is another really interesting sort of uh, identification of a additional right, and this came from France. Uh, uh, this came from France in terms of um, uh, after World War One, you had so many young men artists who were killed that the French legislature realized that they needed to do something to protect, authors and who had parted with their copyright, during that period. So the French led the field in the development of this right, which is known as the author's right. And an inextricable, inalienable right of an author of a work is a right to claim authorship of a work, which is the right of identity or paternity, and the right to prevent mutilation of a work. And this was a famous Amarnath Sehgal case, where in the 60s he was commissioned, Amarnath Sehgal, the artist, was commissioned to make a bronze mural for Shastri Bhavan by Pandit Nehru. It was a centerpiece and a focal piece for many years. Until then, the government, with its usual sensitivity, decided to get rid of it and uprooted it from the hall and threw it in a basement where it shattered into many pieces. And Amarnath Sehgal was outraged and conducted a litigation for more than 10 years, which ultimately resulted in a landmark judgment where the court said that as the paragraph reproduced, they said that the cultural heritage of a country includes artists whose creativity and ingenuity is among valuable cultural resources of a nation, and you need to protect that right of integrity, the right of an artist, even though they may have parted with copyright, even though they may have sold their artistic work, to prevent the mutilation of their work. And the court ended up actually directing the government of India to pay Amarnath Sehgal damages in this case. And an additional right that is adjunct to the right of authors, the author's moral rights, is the jointly suite or the artist's right to remuneration, which is a little known right for artists who have a right, even when they have assigned copyright and sold their work, to benefit from the resale value of their work. And this is largely intended to protect artists who were young when they were developing in their field, and they sold a work for say 10,000 rupees, or 100 rupees in the 60s and 70s, and now the M.F. Hussains and the Tayyab Mehtas, who are now well-known artists, and you have Sotheby's and Christie's doing $1 million and $2 million auctions, and Indian copyright law, much like European copyright law and some other states around the world, mandates that up to 10% of the resale right can be claimed by the artist or the artist's legal heir from the resale right price. And this essentially, as I was saying, after World War One, many French artists had died, and the French government decided, and one of the reasons they said was that this right is the way of the French public to apologize for the insensitivity of their predecessors or their forefathers. And so the artist's right to remuneration, while it's a provision, sadly, this right has never been used in India. It has never been asserted in India for various reasons, but this right is there for artists to take advantage of. So, in essence, I just wanted to kind of encapsulate broad parts of the Copyright Act. While 7 o'clock is not a time when, at least for my time, I would put you all to sleep, but I can assure you that if you allow a lawyer to speak for longer, you can definitely be put to sleep even during the evening. and not a post-lunch session. So thank you for being patient, and thank you for looking at what is essentially a purely legal sort of presentation. But I think our engagement in terms of question and answers would be more helpful as well.
Thank you so much, Mr. Datta. This has been fascinating. We really had no idea that it was such a layered, like a millefeuille, 1,000 layered issue. So before I ask you the million questions that are coming to my mind, I think we should invite our guest discussant, Anita Ratnam, to articulate the questions that have been in her mind. Anita has worn so many hats, and she has the Nartaki journal as well, in which she can look at plagiarism and copyright. And as a performer, her work is immense. And she has actually fought copyright issues, cases, which can be quite unnerving. So, with these words, I'm going to request Anita to please ask her questions. Anita, if you could unmute and start the video.
Yeah, I have
Maybe,
unmuted. You can
yeah,
hear me. Yes.
yeah.
Thank you, Mr. Datta. It's actually a bit intimidating because there's so much information, but I want to address, I want to really share some things because I see so many dancers, so many friends in the audience. And I think let's look at several scenarios from my own experience. A few years ago, when I was in The Hague, in the Netherlands, I watched a really interesting Indian neoclassical performance, which was choreographed by a Indo-Dutch performer called Kalpana Raghuraman. She had been commissioned by the Corso Theatre to create this particular work. I liked the work so much, so I invited her to set the work in India on my dance company. So the procedure for me was I had to ask the Corso Theatre who had commissioned the work, not the choreographer. I asked the producer, who then gave me a 3-year licensing fee, which then allowed the choreographer to come to India to set the work on my dancers. But I also put into the discussion and the clause that the work may need to be adapted on the Indian dance bodies because they were better trained and they could be challenged more. So there was that. Also, knowing the Indian situation, that we have several other kind of venues in which we can do the work other than regular stage. Like, for instance, we have corporate shows, we have lecture demonstrations, we can take an excerpt from a 30-minute work to show maybe in an educational outreach. And also that I would sign off on new costumes that would be appropriate for the Indian scenario. So I made sure to get these things in the discussion, and it was a very smooth licensing arrangement, which then it was very pleasant. And they told me if I ever wanted to extend the licensing agreement, I could continue the work. I haven't since, but that is one example. Another example I faced was when I was co-choreographer with an American production, and I was one of two. So, and it premiered in India, it premiered in America, and then toured in India. But it was produced by the American Dance Company. Over the years, the dance company disbanded, the artistic umbrella disbanded, and my co-choreographer went on to do other things other than choreography. So I was left with an embodied experience of the work. Not I'm only co-choreographer, so I have the embodied experience, but there's not much I can do with it because the rights have sort of disappeared. It's into a tunnel. Very recently, I want to bring up, Mr. Datta, something really interesting that has come up with the digital sphere. I presented a film of the legendary performer Bala Saraswati and her daughter Lakshmi Knight. In the film, Lakshmi Knight in New York, in a friend's penthouse, performed a very traditional composition of a 16th century composer, Chetraya, a famous padam called Payyada. So it's 16th century, but made very well known and famous by that family of the performer Bala Saraswati, her grandmother, and then her daughter. when that part of the film was played on YouTube, that audio got muted. And muted why? The copyright claim was was laid and claimed by a music company called Amudam Music. The CEO and managing director being a very well-known Carnatic singer called Sudha Raghunathan, based in Chennai. Now it's possible that Sudha Raghunathan has also recorded this song, Payyada, like I'm sure hundreds and hundreds of people have sung it through the years. But the music company laid claim on that composition. It was not Sudha's voice. It was sung by Lakshmi Knight's student live in the New York apartment. So when it was muted, we went out and we laid claim. We actually refuted it. And then they released the claim. Okay. Now, this a similar thing happened with the same music company for a young dancer who performed Purandara Dasa's Jagadodharana. Now, this is also a very, very popular composition. Now, the situation would not have arisen if it was a stage performance, I'm sure. But again, being on YouTube, the same music company muted her audio. Now, this young performer was so unnerved, you know, so she didn't know how to lay claim. She didn't know how to say or how to refute this. So this is something that's happening in the digital sphere. Even Astad Debu has had this very similar experience, because he works with lots of Western composers, and Western compositions replayed or recomposed and recorded for him. So this is some of the digital realities that we're dealing with YouTube and Facebook. A situation that we would not have had if we were just doing stage performances. In my own experience of about 30 years of commission. Oh, okay.
Just carry on, yeah. Just carry on.
In my own experience of 30 years of doing what I call thematic work, in which I'd commissioned the music, commissioned costumes, commissioned lighting design, commissioning set design, program notes, everything as artistic director. And in India, in many instances, the performer is also the artistic director, is also the producer, because we don't have independent producing entities. So when you have one person commissioning, paying, and also participating on stage in the embodiment of that work, which was an idea. So you have maybe a co-choreographer or a dramaturg, maybe you have a theater director you have invited to be part of the process. You've commissioned the music and costume, set design. It's a complete work. Now, this work is copyrighted. At least I have copyrighted the work. But many times I've had the musicians who have gone out there and tweaked one, two things and actually done it for another performer. Now, it's very difficult to police this, but my question to you that I think I'd like you to discuss is, do we have to separately copyright set design, costume, music, choreography, or does the producer who pays for the entire production, does that person who sometimes becomes the main performer, artistic director of the company, does he or she really then own that version of the work? Now, in India, many of us working in the classical and neoclassical, we access popular compositions of people who are most often not with us, at least 100, 200, 300 years ago. Meera, Kabir, Purandara Dasa, Kshetraya, or maybe even even Carnatic composers. And what about the entire pedagogy and the movement that has been inherited from, say, Bharatanatyam? Who really owns that repertoire? What are the rights of the dancer or the student of a guru when they have been with a guru for 10 years, 8 years, then they leave, then their lives take them somewhere else in the world. And what if the guru says, I taught you this, it's my work. The music was maybe licensed, maybe not. I gave you permission to do it. Now you can't use it anymore. So what does the student do? Also, what about a group of dancers when you create a theatrical production? 6, 7, 8, 9, 10 dancers who have participated in the choreography. Are they not co-collaborators in the work? Does not their physicality and their presence in front of the choreographer who's selecting and cutting, pasting, adding, creating with them in front, are they not also co-owners of a creative copyright of a choreography? I can go on and on, but I know there are lots and lots of questions, Mr. Datta, and I know we end at 8:15. It's already 2 minutes past, it's 7:52. I want to end by saying that it's only in very few places, like the NCPA in Mumbai, where they ask you when you come in, when you sign a contract, where it says that I hope that all whatever you're presenting is copyright free, that you're not infringing on any copyright. This is something I do, and all of us who performed in international important venues, you have to do it. This is a sign off. This is an agreement that you do it with Royal Festival Hall or anywhere else, Purcell Room, because they don't want to then be hit with any kind of copyright infringements. Finally, the fluidity and the gray areas that the Indian dance world operates in, between respect and submission, between servitude and adoration and adulation and a fan base, and resorting to saying this doesn't belong to anybody, or the rule of the cultural commons, makes it a very slippery and gray area. You know, where do the rights begin, where do they end, and then what does the individual performer and all the people who have participated in that work, does it continue? Is it allowed to continue? Those I see Rama Vaidyanathan in the audience, and I know that she's very in demand for workshops. So when you teach an item to somebody, this is just something I throw out there, when you actually teach an item to somebody in part of a workshop, is it a licensing agreement that you give to that student? Is it a licensing agreement that you give to the student when you give the music and the choreography and the ideas, it's all set? Is it a licensing agreement like I had for this work, Padme, for 3 years? So it's a series of questions, some scenarios that I have laid out, but it's so open-ended, Mr. Datta, and the dancers will have their own set of questions to ask. So this is what I want to present and posit here for this very interesting group, that we need to really evolve a more professional attitude towards our creative choreography work, especially when we look at a non-verbal language like dance. And when we look at the human body and that language, which is not a literary work, and you say it's a dramatic work. So how do we protect our ideas? To what extent can we actually remain possessive about it? And how realistic must we be about this sense of ownership? Thank you.
Datta, would you like to answer first to Anita's questions, and then we will open it to the others?
Sure.
YouTube,
Yeah.
for instance, yeah. Mr. Datta, YouTube, I think, would be interesting, because I think a lot of people are going to find that at least the next 3 to 6 months, everybody has a YouTube channel. Young people are uploading their performances, and many of them are getting muted out because of these claims by music companies.
Right. I want to preface the discussion on YouTube with a very short sort of statement on ownership. Ownership under copyright law across the world, while every country has its own copyright law, largely copyright principles and percepts are harmonized across the world, because everybody wants to live together, and you have multilateral treaties. The Berne Convention is the oldest treaty, initially proposed even by Victor Hugo and the Association of Authors in France, and so it predates a lot of what the English are fond of saying, that They had the first copyright law, but actually the author's system or the individual-centric system came out from France. The author's right principle came out from France. What came out from the UK was how do you make more money out of copyright, and the economic streams and who benefits. Ownership across the world, as a general rule, rests with the person who creates a certain work, whether it's a melody or it's a dance choreography or writes a play or writes a poem or composes music. So it rests with the author. What differs around the world is what is the status of that person who's creating the work? Is that person commissioned to create work by a corporation or a entity or a group of people? Is that person, for instance, in America, is that person engaged under what is known as a work for hire engagement by an entity? And so creators may lose automatically or by arrangement their natural ownership over copyrighted works by virtue of these arrangements. And so they differ territory to territory. In India, where, with the exception of films, which was a very unfair system that persisted between 1957 and 2012, was the scriptwriter, the lyricist, composer lost all their copyright in favor of the film producer by virtue of being commissioned by the film producer. That changed in 2012. For the creative arts, in terms of, for instance, dance, the creator of the choreography, the dancer, or a group of them, would be automatic and natural owners of copyright at the outset. You don't need to register copyright to claim or stake ownership under Indian law and under largely international law in most countries. So, that's important to understand from an ownership perspective. Ownership will change because you have a contract with somebody that dictates or mandates that you're being paid to create something, and so somebody else may end up being the owner, as that example that you gave of the choreography and the choreographer who traveled down from Europe to arrange something with you. Now, when it comes to using, for instance, music, and the problem posed by copyright strikes in YouTube, it's also important to understand that you have a musical composition which from which you can make multiple recordings. Kind of a more simpler example would be a composition and lyrics performed by Lata Mangeshkar in 1970. The same composition and lyrics performed by Anuradha Podwal in 1980, and the same lyrics and composition performed and recorded by a singer this year. Now, each of those recordings has a separate right, even though they are based on the same lyric and musical composition. That's because the sound recording has a separate right. It's a separate right altogether, dehoes the lyrics and music that are used in the recording. So the recording is protected separately. Now, this is what music companies will often misuse. Because they have sourced and own a recording, they are often prone to, whether they do it willfully or they do it, I would rush to say unknowingly, more often it's willfully, they will rush to engage copyright strikes against music that are used in audiovisual productions, theatrical productions, in the hope that they can benefit of the advertising revenue if that copyright strike or muting is not challenged or counter challenged. So they benefit from the advertising revenue then. So what happens is, if your video becomes viral on YouTube and you have not challenged a muting or a copyright claim, very often the so-called copyright owner will say, I don't want it taken down, but I'd like the revenue from the video because of the advertisements that the video will carry, that YouTube will use. And so that revenue motive is why they will do these copyright strikes. I think it's important, I wish I could give you a very simple solution, but I think a simpler solution is to be aware of the distinction between what is copyright protected and what is certainly not copyright protected. And when you are very clear that a composition which you have made a recording for your theatrical production, is not copyright protected. But the recording now that you've created, I mean, the other example could be a Beethoven symphony, which today I can make a recording for, and I will have an economic right in that recording, just as the New York Philharmonic will have a right in the recording of the very same symphony made 20 years ago. And for 60 years, I'll have a right over that recording. Now, so very often it's tough for people to distinguish which is the recording, etc. And which is why you will have this whole series and surges of strikes. It's not uncommon, unfortunately, for music companies to try and strike public domain works. Public domain works are works which are out of copyright, as I said, and which is one of the reasons why I talked about the term of copyright protection. The term of copyright protection for a musical composition and lyrics, for instance, or dramatic work, is life of author plus 60 years. Post that, the work is in the public domain. And so if you know a work is from the 13th century or 16th century, the odds are it's a public domain work. And anybody claiming rights over the composition can't do so.
Actually, I think a lot of people are, they're waiting for
in fact,
questions.
I've got a lot of questions and I'm going to bunch them up in areas. So from dancers, there are a series of questions on this very fine tuning between, a traditional composition or a new composition, music composition, who pays for it and all that. So I'm going to read quickly one or two questions. What happens when which is a dancer's work, music and choreography, both produced by dancers at their own expense, is lifted from YouTube and reproduced on another event, also shared on YouTube? Is this copyright infringement by the event organizer of the event or of the dancers who have copied it? Remember that in both cases, it's on the YouTube. Both versions are on the YouTube. This was a question from Abhinay Nagjoti, from Sunanda Nair, Dr. Sunanda Nair, who says, I'm facing a problem of ripping off of my recordings because of this new area of digital media performances. I had 2 instances last week, because of which we are backing off presenting new important works. Now, the thing to remember is that we don't know how long this COVID problem is going to last. If people don't present the best works, the creativity suffers. It's a loss for all of us. And then Somabha Bandyopadhyay, who is a lawyer herself, says, sir, can we not say that artists using a music of any company or artist to perform their dance item be covered under section 52, which is promotion of culture and dance, etc., especially when it is not given out for revenue from YouTube? And my last question in this grouping is that if a song is written by X lyricist, composed by Y musician, and choreographed by Z dancer choreographer, how will the copyright be implemented if a choreographer wants to copyright his or her choreography in such a scenario where you have so many inputs coming? After this, there's a whole set of different questions, which is across borders as well. So, Mr. Datta, did that make any sense? Hello?
Sorry, I was muted. I didn't realize.
Yeah.
The answer to the first question is where the dancers' work, music, and choreography has been lifted is quite certainly, unequivocally, resoundingly, yes, it's infringement. You are not required to register your works as long as you can show that you had, in simpler terms, created certain works at a prior point of time. One of the examples I was talking with Dr. Arsha Sethi was a long time ago, even now, artists will often, mail to themselves copies of their choreography or their books or their plays or whatever in an envelope, and will keep the envelope unopened in order to prove at a later point of time that I created it at a prior point of time, or
With
at
the
the
stamp.
prior point when it was used by somebody without my authorization. Courts in India routinely protect copyrighted works as long as you can show I was on the scene at a prior point of time with those works. It could be a recording, for instance. And if you can show that, and you can show that you're the owner of that right, and by owner of the right, it means either you've created them yourselves, as you said, or you've commissioned somebody to create them, and you have executed, very simple one-page assignment agreements where they assign all their rights to you. I think it's important to know, if you want the law to protect you, you need to realize that you need to understand some processes where you're getting third parties to create creative works for you, and if you want that ownership, you need to execute those agreements. Whichever you need, they don't need to be complex agreements. It can be simple
We are going to be doing
agreements,
the next
but
session
when you
on
gather those
contracts and
simple white
agreements.
paper agreements will do.
Yeah, we will be doing our next session on contracts and agreements. So this point will certainly feed into that.
Yeah.
On the other questions, do you want a little reminder? Yeah. Then there was this question about um, YouTube. Both of them. Can we not say that the artist using a music?
Yes. Unfortunately, in the Indian Section 52 is not broad enough to allow for promotion of culture as being an imperative, which would exclude, a claim of copyright infringement. It is unfortunate, and that's not because of artists. But that's mainly because of music companies, because the music companies and other corporations will start saying that we promote culture. Even FM radio today doesn't pay songwriters any money and say that we promote the public interest by making people listening to,
Good music.
questionable music, 30 times a day on radio. So, that's one of the reasons. Section 52 is not that broad. If you were in America, the question would have been different because the fair use factors there are exceedingly broad. So, for instance, if you're not really competing with the copyright owner and you're using their work, it could actually be categorized as fair use in America, but certainly not in India, which is a more constrained sort of space.
That's exactly what Hema Rajagopalan from America has written in. According to copyright lawyers here in the US, any piece of music or dance choreography, if changed, is not protected anymore. So one can just change a bit of the copyrighted music and use it as their own. It's an expensive process to keep documenting each thing. Finally, that point that Jay Prabha had mentioned.
The one clarification I'd like to make is even American copyright law, Indian copyright law, goes on something called substantial reproduction. And substantial reproduction means if you substantially reproduced or use something, then you infringe copyright. The test there is not quantitative. It's not because you use 3 acts of a 5-act or 2-act or a 4-act play, but the test is qualitative. So if you use the heart, if you use the mukra of a song, or you use the antara of a song, you left the mukra, but you use the mukra of the song, then you infringe copyright. And so that becomes very, subject to a case-by-case basis. Copyright infringement is not a slapdash sort of principle. It depends on case-to-case use.
So I think that question that Jayaprabha has asked, that what happens to copyright if the writer is somebody, the music composer is someone else, the dancer is another person, and the choreographer has just got covered by your contracts thing.
So
Nalin,
you have a system to clarify. If 4 people get together to create, for instance, a work of a dance performance in terms of choreography, they could be all 4 could be categorized as co-authors, depending on their actual, not by their presence alone, but by their actual contribution to how that work was formulated. and so they could be co-authors. So you could have multiple authors of one work. This could again, you could have four people working with you. There may be co-authors, but you can demand, or you could be in a position where you've executed an agreement and told the other three that I want you to buy out your rights, and I will be the sole owner. You may be co-authors, but I will be the owner of those works. So again, a distinction between ownership and authorship.
So ownership also would imply then that you can bequeath these rights to
Correct.
specific people. Right.
Because
In this,
it's a property.
yeah, in this thing we have present here, uh, Nalin Jain. And Nalin's question was very, very specific. And he actually reached me this question a week ago. Set of questions. I'm going to quickly use them. I would like to use the dialogues, lines, etc. from movies and songs for business purpose, especially from movies of 1960s and 70s and the 80s. I think that really tells what time we are from. What steps I need to take to comply with the copyright? Am I breaking any law? Do I need to give credit or acknowledge the source? If yes, how? Is it possible to use original images? That's from the films itself. What about the images that have been altered using software? What is the legal regimen for that? What if an artistic representation is made of the original photograph? So these are questions being asked by Nalin, who proposes to use some of these popular films of the 60s, 70s, and 80s in his work, which is based mostly in the United States. So the songs and inspiration is from India, but his work that he wants to do is in the US. So, Mr. Datta.
One of the accusations against Bollywood is the lack of creativity, where remake rights are all the rage. They seem to have lost, their appetite for original screenplays, and there's a whole host of remakes of either Tamil films or Telugu films into Hindi or old Hindi films. Certainly, it would be a copyright. It would amount to copyright infringement if you use dialogues, or if you used, elements of a film, including images or photographs, etc. For any use, business or otherwise. If you use your personal use, again, the limit, the fair dealing, or the principles of fair dealing or fair use in the US would apply. But a good example of the use of images is, if I have an image and I use in the US, is if I use a thumbnail size version of that image. In the US, it's categorized as non-infringing because I'm using a smaller image which does not displace the market for the normal sized image. But in India, that may not necessarily be the case. So definitely it will amount to an infringement if you use any film. You have to be very careful to ensure that the film copyright is expired. And if you're using dialogues, then you have to go back to life of author plus 60 years, which could be more than 100 years. So at this point of time, sound recordings, films, the underlying works, as we call them, lyrics, music, script, they are still within copyright. A lot of the films, interestingly, you can exhibit in India a film whose copyright has expired. Say a 1950 film, whose 60 years are over, copyright has expired. You can exhibit that film without infringing the works that are underlying that film. But if you start taking out the dialogues from the film and start using it somewhere else, then you're infringing rights. But you can exhibit that film for free if that film copyright has expired.
We are at 8:15, and this is normally where we round up and wind up our sessions. And I'm sure you must be quite tired having to deal with so many questions. There will be some more, and we promise people that we'll send replies back by emails. They're all popping up again. Listen, Sangeeta, onwards, I will give you back replies on emails. Sorry about this, but time really flies, and this subject is so complex and complicated. Really, I think Somabha, who is a lawyer, she's also a lawyer and also comes from a dance and arts background, is the one who could talk about Section 52 and all that. We are still trying to come to terms with it. And what I definitely see a possibility of is a series of workshops on understanding copyright better. Now,
Right.
your slides I could share with the people, but
Yes,
I
please.
noticed that you have C copyright written
No,
at the
that's it.
bottom. You don't mind if I
No, no, no.
share it?
Please,
Right.
I relinquish copyright. You are allowed to do that under the Copyright Act.
Thank you so much. Thank you very much, Mr. Datta. You have been more than generous sharing your time and then relinquishing your copyright on the slides. Anita, thank you. Your real life anecdotes, stories, just linked it up so beautifully with the legal point. Arnab, I know, I'm so sorry. I will get an answer for you by email. Okay. Thank you very much for this. This was one session that we were oversubscribed. We have a huge lot watching on YouTube right now because we just had to run live streaming and on Facebook as well. And so I'm really happy at the way this whole arts and the law series is picking up.
No,
Our
but
next series.
thank you once
Sorry.
again for reminding me that lawyers need to get simpler and less complex. It's another reminder. It's important for lawyers as well to kind of get contextual. And so that's great learning too. When we engage with the creative community, that is an invaluable takeaway for lawyers like me. Thank
No, Mr. Datta. Actually, the thing is that for too long, the arts has been in this fuzzy sphere of stratosphere.
Yes,
We come from the gods. We are this. We are that. Oh, there's no real lifeness.
yes.
We need to infuse more real lifeness to the arts, and that's what you've just done for us. We will try and, as a group, work on understanding copyright much better and plagiarism, because it's really a big issue today. The YouTube references and Anita leaving her issue on YouTube was a very important thing.
In part,
You-
I just want to tell everybody, and I want to kind of give a message that India is probably the only country in the world where, for music composers and lyricists, we now have from 2012. I worked on those amendments to the law. From 2012, whenever a piece of music is used in a film or a sound recording or a lyric is used, the artist has an inalienable, non-assignable right to an equal share of royalty from the exploitation of that music, which means they can't assign it. They can collect it through the Copyright Society. Music companies, film producers are not allowed to grab that right. So
right.
50% is there, and that's benefited a lot of artists. And if anybody is creating music, etc., you must be aware of that right as well.
Thank you so much. Thank you for this last tip. To all my artist friends who have joined this webinar, I just want to remind you that we meet next on the 24th of November at 7 p.m. And our subject is contracts. You know that Mr. Datta talked about creating a record of the making of any creative work, and to have white sheet contracts, letters, to sort of commitments and all that. Uh, so we will understand that and much more next time. Soon you will get your message. Thank you very much, Mr.
Thank you.
Datta.
Thank
Thank
you.
you, Anita. It's been a
Thank you.
pleasure having both of you.
Bye-bye.
Thank you.
Bye.
Bye. Happy Diwali to
Bye.
everyone.
Oh, yes.
Bye.
Sorry. Happy Diwali. Please do not burst crackers. We are having an acute pollution problem.
Diwali. Okay.
Thank you so
Bye,
much.
everyone. Bye bye.
Bye. See you.